the cab rank rule. Why on earth am I standing here talking about something which, on the face of it, is quite laudable, it's innocuous, doesn't seem to harm anybody particularly, and yet I and my co-author, an economist, we spent several months looking into this, and in the process incurred the wrath of the bar. Now, Justine mentioned the Legal Services Board. The Legal Services Board is a new super regulator, oversight regulator. The idea is that under the Legal Services Act in the UK, every component of the legal services market, not profession, but market, must have its own regulator. However, these regulators don't always get on with each other, they have different kinds of rules and so forth, and so we have an oversight regulator that basically says just regulates the regulators and says, make sure you do everything in accordance. And part of the job of the LSB is to ensure that the market is fair, is open, and not distorted in any way. This is one of the regulatory objectives of the Legal Services Act, 2007. Okay, so the LSB asked me and Morten Hviid, my economist colleague, to look at the cab rank rule, because they were unsure as to whether it was distorting the market. Cab rank rule very simply says, you mustn't refuse a client because you don't like him. I'm sorry, I'm going to use the male for the moment. You don't like the crime he's committed. And it also says something too about, the source of funding and so on. Very simple. So why would that distort the market? Well, our report was published last January, just over a month ago. Within the first week, we started receiving comments. Let me give you some of the comments, and then I'll tell you how we got to that particular point. The chair of the Bar Council, Maura Gowan QC, wrote, the LSB has commissioned a report, in quotation marks, on the cab rank rule. It seems a bizarre thing to have done, and is now being described as a discussion document, in quotes again. There doesn't seem to be much to discuss. The rule operates in the public interest. End of argument. She goes on to say that they're going to draft a reply, and that the particular drafter might know a little bit more about the subject than the LSB's hand-picked academics, me and my co-author. And goes on to say, we think the senior judiciary will have something to say about this too. The chair of the Criminal Bar Association went a little bit further when he wrote about the report. His first sentence was, how dare they? This is a further demonstration that the Legal Services Board is a politically motivated body whose mission is the wholesale destruction of the criminal bar. We're just mere vehicles for that destruction. He goes on to describe the report as a crassly ignorant analysis of the cab rank rule. Read it and weep. And then the last comment I will give you, somebody said, yes, this is what we expect from half-educated half-wits who become professors. So, trying to live up to that kind of opening. Why did this, come up with this? And by the way, the comments are still coming out. We're waiting for the final report to their response to our report to come out. But one thing I will say about the bar's reaction so far, as you might gather from that, is they haven't actually said anything about the substance of our report. What they've done is to attack us. My co-author, by the way, who's an economist, who's never worked with the legal profession before, is sort of hunkered down inside his bunker wondering what the hell's going on, and why the media is suddenly focusing on this thing that he's done. So let me try and give you what it is that we did. We were asked to look into the rule and to see. So the LSB basically asked us to do a literature review. So we wrote our proposal for this piece of research, and in doing so, we did the literature review. Why? Because there's hardly any out there. So in effect, by the time we'd sort of gone through it all, we said, well, okay, look, if all you want the literature is the literature, then we've done this. That's there. Don't need to worry about it anymore. And they said, oh, well, that's not really enough. No, we said, we don't think it is. So what we want to suggest is that we do some empirical work for you. We'll go out and do some interviews, we'll get some data, my economist colleague will do the modeling and so on. We'll come back with some, sophisticated work for you that will let you know what this is about. There we hit our first problem, our main problem. We asked for data. We asked the Bar Standards Board, we asked the Bar Council, we asked various other bodies for any data in relation to this. And the answer came back, there is none. And in fact, the Bar Standards Board has a page related to disciplinary findings of barristers who've contravened the rules in various ways. We said, how many have you sanctioned for contravening the cab rank rule? It took them 2 days to find out there were none. So, oh, strange, such an important rule. And they do view it as important. When I interviewed Bar Council on this, they said, without the cab rank rule, the rule of law would disappear. We're no longer there. So it was a bit odd. The one thing we couldn't make sense of is why this very simple rule in the code has about 8 sets of exceptions, which are far in excess of the simplicity of the rule itself. First of all, it only applies to self-employed barristers. It only applies to barristers who are instructed by solicitors, not by clients who instruct barristers direct, which we can do in the UK. It has very limited effect on QCs, and there were various others, which I won't go into. So if we look at the legal services market in the UK, not the profession, but the market, just to give you an example, there are 150,000 lawyers, approximately, 250,000 people working in the legal services market, and now, we talk about legal services suppliers rather than just lawyers. The bar constitutes something like 5% of that, to which this rule applies. Why is it so important? Our argument is that it's to do with status, it's to do with belief in a particular position in society and so on, which I'll come to. So where does the cab rank rule come from? No one really knows. We've got a quote from some historian in the 16th century in Scotland. It gets mentioned. You would be effectively struck off if you didn't take briefs. But really it comes to the fore in the 17th century when Charles I was being tried, and they looked around for a prosecutor. Most other lawyers took the hint, left town, and John Cook was left behind, and he got the job, which he did very effectively, as we know, and he got a judgeship in reward. However, after the interregnum, and Charles II came back, there was a grand hunt for all the regicides, which included John Cook. John Cook said, of course, it's the cab rank rule. Well, he didn't say those words, that didn't exist at that time, but he basically put forward the argument that he was just acting for his client. And they more or less said, yes, but the consequences are, you're going to be hung, drawn, and quartered, which he was. I have to say, since then, no other barrister has put their principles on the line in quite the same dramatic way as John Cook did. Now, since then, this has become tied up with immunity for barristers against negligence proceedings and so forth. Those are gradually being whittled away. There's really no immunity now for barristers, especially in civil matters and increasingly, or I should say, less by less in criminal matters. And it was thought that because they applied the cab rank rule, they should have immunity. Well, that's less and less. So what is the situation? First of all, I refer to self-employed barristers. Barristers are nominally, and I say this, nominally self-employed, solo practitioners. And the reason that they like that is it allows the way they operate in sets of chambers to be able to appear on both sides of cases and all those sorts of things. It also, relating to what Justine was saying about her research on pupils and so on, allows them to control the production of producers as well as the controlling the production by producers as well. It deals with the issues of conflicts, as I've said. But this, we argued in the paper, is something of a smokescreen. Because really, what's happening now is only 4% of the bar operate as solo practitioners, the rest operate in chambers. Chambers are a collective enterprise. They have clerks, they have a head of chambers, they have management committees. They do all the things that law firms do, except call themselves law firms and ostensibly share profits. But more and more, the competition in the bar is taking place not at the level of the barrister, but at the level of chambers. We see chambers merging. We see chambers getting rid of areas of practice, raiding other chambers for their own specific areas that they want to add to their practice and so on. So the idea of this bar as a pristine area is diminishing as well. Now, the other thing to say about law is law has a dual character. On the one hand, it's a credence good. I'm moving into my economist mode now, which means that you buy on the basis of belief. You can't really evaluate it terribly well as a lay person. In effect, you don't always know whether somebody's done a good job or not. Well, you might end up at the Legal Service Commissioner's office making your complaints and so forth. But on the whole, you're never quite sure. The other aspect to it is it's a distress good. You buy it because you have to, not because you want to. You buy it in times of stress, need, or if you're a corporation, because the regulations insist that you might need that sort of help. So, whereas the cab rank rule will assist you to get the next barrister in the taxi rank, so to speak, it won't necessarily guarantee you the performance that you want from that particular barrister. It gets you the person, it doesn't necessarily get you the performance. It says nothing about performance in that way. And really, when we came to look at it, we tried to model the relationship. Now, normally, you can model things in terms of principal-agent. So, principal-client, agent, the person doing the job. It doesn't apply here because we've got a three-step one here. We've got the client, the solicitor, and the barrister. So the model we came up with, borrowing from a French economist, was principal, supervisor, agent. So principal client, supervisor, solicitor, agent, the barrister. The problem with that is the basic problem of multiple relationships. They allow for coalitions, they allow for opposition, they allow for groups to affect and be affected against others. So in this case, it's quite feasible for solicitors and barristers to align themselves against the client. Again, we cannot actually say if the need for the client is really being served by this. So what then about the particular clients themselves? I said that the basis of the cab rank rule is to make sure that the undesirable client, the dislikable client, is protected in some way. When we came to look at how many times the cab rank rule had been invoked, we came up with two instances. One was in the 1970s in the UK when the Irish Republican Army blew up a pub in Birmingham in the mid-70s, and the Bar Council had to ask GCs to go in and defend these people. Interestingly, they ended up being acquitted later on, many years later. The second time was in the 80s in Sydney, Australia, when there were prison riots and the bar was loath to cross-examine prison officials and police and so forth. That's it. That's all, pretty much, I can find where the bar has said, no, we won't act in that favor. And in fact, since the 1970s, our argument is really, this has changed enormously. In fact, the undesirable client, as defined in the code and as we know, has now become the desirable client, the wanted client, the client that everybody dreams about. When O.J. Simpson was thinking about rejigging his defense team, one particular lawyer was interviewed as a potential candidate for the defense, and he was asked how he wanted to be paid, and he said, easy, I want a reverse contingency fee. If we lose, you pay me. If we win, you don't. Why? Because the resulting publicity of a win was going to far outweigh any economic profit from a fee. He would have been made for the rest of his career, as many of the defense team of O.J. Simpson were. And in fact, you can more or less pick any kind of undesirable client these days, and they will get a defense straight away. There is a set of newspapers in the UK owned by a corporation called News Corporation, which I think was started by an erstwhile Australian who now lives in New York. And his chief executive during the phone hacking scandal was fired, Rachel Brooks, and she's being charged with corrupting police officers and various other things and so on. It is strongly rumoured amongst the bar, I haven't got the actual facts, but it's strongly rumoured that she's getting her defence at a reduced rate. Again, the publicity is going to be so big that she doesn't need to pay the full fee. It is also said that if the Norwegian who shot up all those children on the island a couple of years back in Norway had been English, lawyers would have queued around the block to do his defence for free. And those sorts of things kept coming back. So why then is there this concern about these particular kinds of clients? Because it's actually not really about the clients. It's really about the money. And this is where the cab rank rule and everything else gets a bit murky. Because the cab rank rule actually says, well, you should have a proper fee on the one hand, but actually the source of funding and everything else shouldn't matter too much on the other. I don't know whether it was a coincidence, mistiming, or what, but about a week after we published our report, the bar published its new standard terms of contracting with solicitors. And the big thing in the contract said was, if you try to deviate from this contract in any way, the cab rank rule will not apply. Now, it was a bit of a surprise. But then when you look into it even more, you find that there are areas which are outside the scope of the cab rank rule. When I talk to legal services officials in government about this, they said, oh, well, yeah, certain fees are undeemed and some are deemed. I said, deemed and undeemed, I've never heard these words before in this particular way. Oh, well, the bar takes a collective view on what it thinks is a proper fee. And in the case of publicly funded criminal defense and publicly funded family law, the bar has taken the collective view, this isn't a proper fee, it's undeemed. Undeemed means the cab rank rule doesn't apply. I thought that was a bit strange because I thought, well, there are two areas of law, perhaps where people need representation the most. The bar is saying the rule that would defend them, would give them representation, doesn't apply. And increasingly, as the bar has become embittered, beleaguered, and Justine talked about crisis, it's still in crisis. As far as the bar is concerned, you heard me say, the chairman of the Criminal Bar Association, this is part of the wholesale destruction actually they believe this. They really do think they are being preyed upon by government. Now, Rick Abel, when he wrote his first book on the English legal profession some years ago, said that up to 50% of the English bar was paid out of state funds, basically from publicly funded work. That's an awful lot of people to be funded by the state in that way. Nothing wrong about state funding for cases and so on, but it's not a right. It has to be earned, if you like. We found the sort of situation where this becomes very critical. And here I'm going to change the approach a little bit. Some years ago, some years ago, my very, very first research project ever was a study of barristers' clerks. They're different to Australia, but the English ones, these are the guys who negotiate the fees, do the diaries, tie the shoelaces, all sorts of things for their barristers. You think that tying the shoelaces one is facetious, it's not, it's true. And they used to be paid on a percentage basis. They would get 10% of the brief fee. Now they're on salaries, but they're still there. These are the guys who, in effect, when the client comes into the chambers and says, I need a barrister, this is the intermediary you go through. So for all of the invocation of the cabaret rule, the actual working of it is done through these barrister clerks who are not lawyers, they're just clerks, basically. Very well remunerated clerks, I should say, by the way. And so when I spoke to one clerk and I said, well, you know, what about a cabaret call? He said, I haven't thought about that for 25 years. Oh, that's interesting. He said, yeah. No, it doesn't mean anything. So I said, well, what happens if somebody comes in and says, you know, I want this guy to represent me? He says, well, I quote him the fee. What do you mean? Well, he says, oh, if I know, you know, I know Mr. X doesn't really want to do that case, so I'll just quote a fee that will tell the solicitor, you can't have it, it's too expensive. Another one would say, oh, I'll just tell him he's overbooked. Sorry, he's not available. And so what you find is within the chamber system, there's a series of sort of covert machinations going on, which basically protect the barrister from actually having to deal with the rule in any case. Now, but you do get situations where it gets a bit awkward. So let me give you one, because this one kept cropping up all over time and time again. It's called the each way. There's a thing in England called the each way offence, which basically means you can either be tried in the magistrate's court or in the superior court, the Crown Court, before a jury. It's up to the client, the accused, to decide which way. Now, on, say, take a benefits fraud case, which is the sort of thing that crops up. There's a fixed fee for going to the magistrate's court, there's a fixed fee for going to the Crown Court. If for some reason the client elects to go to the Crown Court, and then before the case is heard, changes the plea to guilty, the resulting fee is less than you would have got if you'd gone to the magistrate's court in the first place. It's a penalty, basically. So what the clerk and the barrister have to do, work out is the client trustworthy? Is the client going to go the whole way? Is the client going to break? Is this client, you know, tricky or not? That's the decision about whether you take the case. The other thing that's happening now is that the way these cases are paid, it used to be that the barrister received a payment, the solicitor received a payment, everybody was happy as far as from the solicitor's perspective, the barrister's fee was a disbursement, didn't have to worry about it. Now, all the payments are made to the solicitor, who then allocates them amongst the other people working the case. At this point, the barrister is now a profit center. And therefore, the amount of money that goes to a barrister or doesn't go to a barrister becomes crucial to the way the solicitor runs his practice. And in that respect, solicitors are now sitting in the controlling seat. And so for them, they can command resources from the barristers because they really want work. You know, you expect to do things for me. And this is sort of changing the way things are working. Also, the cab rank rule has a particular influence on the way specialization is dealt with. Not somebody, say, doing tax work or somebody doing crime or anything like that, but if you're doing prosecution or criminal defense, technically you can't say that that's what you do because you'd be in breach of the Cab Act rule. But everybody knows, those in the game, in the club, the solicitors and the crime prosecution service and so on, they know who does what and will only instruct what, but anybody else would not. In family law work, for example, there are certain barristers who only represent local authorities, local governments in care proceedings, whereas there are others who will only represent mothers and children in those kind of care proceedings. Again, no one knows that except those in the club. So we've got this situation where people are developing their practices, but they have to develop it kind of covertly, under the radar, although everyone knows except those involved. The only areas where we've begun to find where this might have an impact is in the civil area, which I haven't really mentioned, and I'll just bring it into play in the last moment, is there are certain areas where perhaps there are very few barristers in some very high-level tax work, very high-level pensions work, and so on. And there, maybe the Cab Act rule has a positive benefit. We don't really know because, again, there are no data on this, so we don't actually know. Although, having said that, it was reported to us that the tax authorities in the UK prefer the people they instruct not to act for the other side. So there's already deterrence at bay. So how do we end up deserving the ire that has been inflicted on us? Because in the end we said, well, look, the Cab Act rule is not a rule. You know, take Dworkin's analysis and so on. This is not a rule, it's a principle, it might be a standard, but it's certainly not a rule. It doesn't, there are no sanctions, it's never been used, there's probably no way of enforcing it, even if you wanted to. So, okay, it's not a rule, it's a principle, fine. You can have your principle, we don't necessarily want to get rid of that. But you might want a rule that protects people. You might want a rule that, in fact, affects the entire legal services market. So we proposed a rule that came from the New York State Bar, which basically said no one on the basis of race, creed, etc. Should be refused representation, to which we sort of would add in particular nature of crime and other types of cases and so on. And what we would argue is that there are fundamental reasons why you cannot refuse representation, but there are reasoned bases for why you might want to refuse representation, and those ought to be above board. And also, this is something which we think our legal ombudsman should be able to handle as well. The legal ombudsman is not aware of having any complaints on this as well. Because we have shifted the nature of the rule away from the bar to the entire legal services market, I'm afraid we've undermined the status of the bar, or they perceive we've undermined the status of the bar, and as such, I may live when I go back to the UK, I don't know. The one thing I have decided to do is, when I get back, is say, okay guys, you know, if you really, really think that what I've done is rubbish, let's have a debate like this, come out, and let's go head to head on it. Bar doesn't like to do that too much in the UK, but we'll see. I'll let you know what happens in the next couple of months. Thank you very much.